All right, Vince, can you Vince-plain the Chevron decision to us all, please?
Oh, boy. So, right in the last day or two of their term, the Supreme Court came down with a ruling that did away with what's called the Chevron Precedent.
Yeah. Where does this come from? Like, where did this start?
So 42 years ago, okay? This is not something that's happened recently. We've been decades of this. And it was a Supreme Court decision in a case involving Chevron. Mm-hmm. And the basics of it are pretty simple and you'd think pretty workable. The thing here is that, government agencies make a lot of rules. A lot of times politicians, they write a law that says, we're going to regulate X, or we want to make sure that there's a cap on Y, right? Hey, let's ban social media, or let's regulate social media, or let's, regulate financial services. Yeah. Let's regulate environmental protection, the agriculture, all this sort of stuff. That's right. So they say, here's something we want, but they don't write it in minute detail.
Yeah.
Somebody's got to interpret what was Congress trying to get us to do here. And what happened was the Supreme Court said, all right, given that all the government agencies are stocked with people who do this day in and day out, work with this stuff, they have expertise.
All the regulators out there. Like an example of a regulator would be
a CFPB.
Yeah.
That's, the OCC, anybody who's in this, the FDA, the FTC, the FCC, all of these things that say, here, how are we going to regulate this stuff? How are we going to put rules into place? Hey, you got somebody who says trigger leads. We're going to ban them. But what does banning them mean? Who can use them? Who can't use them and stuff? You have the agency that looks and says, okay, we've heard all this stuff. We're going to promulgate rules for this. Now, somebody doesn't like those rules. They go to sue.
Yeah.
Under the Chevron discipline ruling from the Supreme Court, judges, where these cases would come, judges would then look at it and say, well, if the agency made a reasonable determination, given that they are experts in this, we are going to defer to the expertise of the agencies. It's like your doctor tells you something and your landscaper weighs in on it. You might want to go with what the doctor has to say if it's a medical situation.
Yeah.
Right?
Yeah.
Give deference to what the doctor has to say.
Yeah.
Except we've got a Supreme Court now that doesn't believe in any of that stuff. They don't believe in the executive power. They believe that everything ought to be coming through both the congressional and then the judicial branch. So if Congress doesn't write it down to the nitty gritty, they did away with Chevron. The courts no longer give deference to the state agencies, which means, go ahead.
Break down an example of how this would work, in our industry.
Well,
so use let's say a regulation that we're facing right now.
Well, again, let's talk trigger leads, for example. Okay, so if legislation ever went through that said we're going to ban or regulate trigger leads and something comes through, bear in mind you've got industry folks who are in there saying, well, we want to ban them from general sale, but we don't want to ban them if we're the lender that already has these as customers, right? So there's got to be some thing in the legislation that specifically lays out, well, who are trigger leads actually still available to, and who falls under that, and then who can't access this. And then the idea, remember, is that legislation is written today, but in 5 years, things may have changed. And the whole marketplace may have changed. So the CFPB, the FTC, may both get involved in these things and then looking at the law that says, here's what happens, say, well, under the spirit of the law, here are regulations to how to implement this.
Well, so, we right now have things like with trigger leads that are just being ignored, where you have actually mortgage brokers getting involved in trigger leads. So they're already, ignoring what the regulators, have.
This is a different question that you're heading off onto, which is enforcement.
Yeah.
Enforcement is a different thing, although it comes back into play. One of the things that happened here, one of the reasons the Supreme Court got involved was, this is actually a case involving fishermen who were, this was a Commerce Department rule. They said Commerce didn't really have the right to create these rules that affected the fishermen, and that the courts shouldn't have given deference to them. So they sued and won. Now, what would happen in that case is the broker might go, hey, the CFPB or the FTC doesn't have the right to make these rules and sue and win once somebody actually tries to enforce it. The bigger problem that's going to be here is it used to be that because companies with lobbyists, Mortgage Bankers Association has many, many lobbyists, and so does the American Bankers Association and the Consumer Bankers Association. NAR, all these folks have lobbyists that go in here for housing and real estate and mortgage-related issues. You used to be able to go, well, okay, we'll negotiate and what the regulations ought to be. Not a lot went to court because they already knew that the court would had to give deference to this agency's interpretation. So you try to work it out early. And then everybody has some clarity on how to proceed. The problem right now is nobody's going to have any clarity because you can sue at any point.
So now the big liability is when there is reason to question a decision, the courts are going to be so clogged up.
Listen, yeah, and you don't even need to have reason. You just sue.
Yeah.
Just sue.
But when there's an actual legitimate reason, that legitimate reason is going to actually have to go after all these other...
Right. These agencies are still going to have to do their usual, rules for promulgating regulations. They have to put it out. So much time for comment, so much time for hearings, all this sort of stuff. We already know that can take like a year and a half or stuff. Yeah. Well, then it gets to court. And again, if anybody's been looking at how court cases go this year, we've had some very good, very high-profile examples that they could take a very long time. And
this is going to impact every regulated industry that's out there.
You're not going to know what's lawful and what's not. That's the big thing. You will not know what is lawful and what is not because everything is up for grabs. And although in this decision that came down, the Chief Justice, John Roberts, who wrote the opinion, said that this shouldn't be applied retroactively, automatically. It shouldn't just anything that was decided under the Chevron doctrine in the last 42 years isn't automatically thrown out. That doesn't mean people can't go and sue anyway and say it should have been. Say, okay, now we're going to challenge this rule that we didn't challenge before because now we know that we don't have to go against what the government interpretation is. So our courts are going to get completely clogged. We're not going to add more courts. We're not going to add more judges. We're just going to add a lot more cases, and there's not going to be any finality, and there's not going to be any clarity. You will not know what is legal, period.
It's like the Wild West.
Yeah, that's where we are. Thank you, U.S. Supreme Court. Lovely. I'm going to take a win on this one. And I'm not
win. How do you win?
No, I'm going to say, hold on. I'm going to take a win on this one because obviously what I'm saying is 100% correct. But I'm not happy that I'm getting a win on this. I would love to be wrong. Okay, you got it.
For more on these and all of today's top stories, go to nationalmortgageprofessional.com.